One thing I would look out for if I were y'all is to see if this case actually gets dismissed. By now we've already heard about the mass layoffs occurring at Twitter 1 week after Elon Musk purchased it. But what we do know is that Twitter just laid off 784 employees in San Francisco, 106 employees in San Jose, and 93 employees in Santa Monica. Hi, my name is Adam Juratovac, and I'm a California employment lawyer located right here in San Jose, California. And I've had a lot of employees contact me regarding the severance agreements they've received after a WARN notice. And now we've already heard about the class action lawsuit that's been filed on behalf of Twitter employees against Twitter for failing to provide them proper notice of this mass layoff or mass termination. Now, the main law behind that class action is the Federal WARN Act, or the Worker Adjustment Retraining and Notification Act. And in the state of California, we have our own little mini WARN Act. Now, before we jump in to see if Twitter allegedly broke any laws, let's go jump into California's WARN Act. Now, when we're looking at laws, every single word in that law has a purpose, a meaning, and a definition. So I'm going to first start naming the explanation, and then I'm going to describe what each of those words mean in that explanation. So let's just jump into it. So California's Workers Adjustment Retraining Notification Act requires employers to give employees at least 60 days notice if there's a 1, a mass layoff, 2, a plant relocation or a plant closing, or 3, if there's going to be ceased up operations, meaning the whole thing's going to shut down. Now, when we're looking what a mass layoff is any termination, any separation of 50 or more employees within a 30-day notice. So think about if your work is firing 50 or more employees within 30 days, then that's a mass layoff within the definition of the WARN Act. So if that's the situation, your employer should give you WARN notice of that potential closure, of that potential layoff. Now, we all heard about mass layoffs, right? But who does the WARN Act apply to? What type of employers are required to follow these notice requirements? Now, when we're looking at private employers, so employers that are not governmental entities, think about any employer that employs 75 or more employees within a 6-month period of time. So meaning that if your employer has 75 employees who work full-time or part-time, and they're all there for the past 6 months, then those qualify as a 75 employees, and that employer now is entitled and required to give all of those employees WARN notice if there's going to be a mass layoff, mass closing, or a relocation of those duties and services. It's really important to think about this because when you have 50 or more employees getting terminated or separated within that short period of time, you deserve to have notice. You deserve to know when there's going to be a lot of people within your community also being laid off at the same time, because then that allows you to budget, that allows you to set your future plans, and also allows you to schedule your life because you need to get a new job relatively soon. And that's one of the benefits of the WARN notice. It's when people are going to be terminated, when there's going to be a mass amount of people within a community looking for a position, and even if they're similar positions, you want to give people as much notice as possible as to not impact or affect their life, and you want to impact it as minimal as possible despite the huge drastic change that family and that individual is going through. And that's one of the reasons why we have the WARN Act, is so people and families can set their life up and they can schedule their future. Now, one main purpose of the WARN Act is to give you notice, right? To give the employees notice that there's going to be a mass termination, layoff, or plant closure. So let's look at the types of notice requirements. What notice your employer, or what notice Twitter was required to give its employees once it learned about its mass layoff. Notice requirement number 1, the employer must give the employees who are affected by that mass layoff notice that there is going to be a mass layoff. And number 2, the second group that employer needs to give notice to is the local workforce investment board. And the third group that employer needs to notify is the chief elected official in the local city and county where that termination, layoff, or relocation is going to take place. Now, those are the people that the employer should notify. Now, this is the actual notice requirement. This is the information that the employer needs to provide those people with. Number 1, whether the employer expects this action to be temporary or permanent. Number 2, whether the entire plant will be closed or just a portion of it. Number 3, the expected date of the mass layoff or closing. Number 4, the expected separation date of the employees. Number 5, the company's contact info in case any of the employees want to reach out to the employer for any reason whatsoever. Now, one question is what happens if your employer violates the WARN Act? Now, what we learned within 1 week of Elon Musk purchasing Twitter and taking it over is that he was going to submit and he was going to implement mass layoffs amongst Twitter's staff. And we knew this. We knew this because he was talking about it in the news. We knew this because he was tweeting about it. And we also knew that he was looking at different ways to monetize using Twitter's platform because apparently it hasn't been doing too hot in the market. But one thing you need to do before you terminate half your workforce if you're Twitter is in the state of California and under federal law, you have to give each of those employees WARN notice, which means you need to give them 60 days advance notice of a termination, mass layoff, plant closure, or removal of the operations from one location to 100 miles away. And Elon Musk didn't do that. Elon Musk didn't give all of his employees 60 days notice of their termination, 60 days notice of that mass layoff. Now, I haven't gotten a hold of one of these severance agreements, but I have heard through tweets from Elon Musk where he actually indicated that he's providing each of those employees who have been impacted by this mass layoff a severance agreement. And in that severance agreement, he even says it here. Apparently, he's providing all of his employees a 60-day severance agreement, which is, essentially the WARN notice that he was supposed to provide these employees with. Now, when I say that WARN notice that he was supposed to provide employees with, just imagine if your employer gives you 60 days notice of your termination of your layoff, that means you're going to get 60 days of wages before you're actually terminated or laid off. So that means you're able to stack your cards, you're able to make your plans in the future, and also look for other jobs during that time. Now, if this is true and Elon Musk and Twitter did not provide any of the employees with a 60 days WARN notice, which it doesn't look like they did, but if Twitter also provided each of those impacted employees with a 60-day severance, what does that look like? Do you think that that should be okay, or do you think that Twitter and Elon Musk should still be dinged for not providing that 60 days advance notice to those employees? Now, the Twitter employees are alleging that there's been a violation of federal law because Twitter did not give them that WARN notice. Now, that headline looks great. That headline looks awesome because it is true. 60 days notice was not given to the Twitter employees. But the question is Twitter liable for all of those penalties, all of those damages, and everything that that complaint alleges in that lawsuit? And the question is, we don't really know yet because there are a lot of exemptions. There are a lot of factors that are taking place behind the scenes that could either minimize the risk taken on by Twitter, could minimize the liability that people are going to be thinking that Twitter is exposed to. And here's a couple of things that Twitter did in the last couple days to reduce their risk, to minimize their liability. And who knows, they may make this lawsuit moot. Now, remember how I told you how this lawsuit was taking place in federal court? Now, under the Federal WARN Act, your employer is actually allowed to provide the employees 60 days pay in lieu of giving them that 60 days advance notice of the mass layoff. Now, if the tweet that Elon Musk posted is true and all of the employees were provided 60 days pay as a severance in lieu of that 60 days notice on the WARN Act, then their liability may be reduced to zero. Now, that's in federal court though, right? And like I said, Twitter is in the state of California. We just talked about all the layoffs that occurred in San Francisco, San Jose, and Santa Monica. Now, if you're looking at California law does not actually have an equivalent to that federal law saying that you could reduce your liability by giving your employees 60 days pay in lieu of having that 60 days notice. So Twitter's liability for not giving the employees 60 days notice actually can be reduced. And it can be reduced by, one, looking at how much pay the company gave to each employee that they were not entitled to. So just imagine if you already had your accrued but unused vacation time, you already had wages that you were being paid out, and your employer gave you that. Your employer gave you your wages, and your employer gave you your accrued but unused vacation time. But then in addition to that small chunk of change, they also gave you 60 days severance. Now, you're not working at Twitter anymore, but you're still provided that 60 days buffer to plan your future, to get a job, to pay your rent for the next 30 days while you're trying to search for a job in a recession. And that's one of the reasons why we have the WARN notice. One of the reasons why we have the WARN notice is we don't want to screw over employees, and especially a lot of employees who share a community, who shares one type of work, who share a profession, and have all of those employees looking for jobs at the exact same time, because there could be periods of time like this where we are in a recession and where there are not that many jobs. And we want to make sure we keep all of these employees like as structured as possible to make sure that they can plan their futures and they can find new jobs, leading them to live happy and successful lives. Now, one thing that the law does not fully account for, especially when it comes to labor code violations, is emotional distress. Now, our one question to think about is the 60 days severance enough? Do people believe that because they were not provided that 60 days notice of that termination, that they were so emotionally disturbed by that news, by that information, by the shock of having half of your workforce being threatened termination? Now, if we're looking at California Labor Code, if it's a normal wage and hour violation, there is no damages for emotional distress. And that's no different with California's WARN notice. Although you can receive back pay, although you could receive some damages, in certain cases it's even possible to get punitive damages, but not emotional distress damages in this case. So we talked about some penalties, and we talked about how Twitter did not provide those employees 60 days notice, but what are Twitter's penalties going to be? What is Twitter going to be entitled to pay? Well, that will be determined in court. However, the California Labor Code under the WARN Act states that there can be a penalty of up to $500 and attorney's fees for each day that the employer is found in violation of the WARN Act. Now, like I told you earlier, every single word is important when you're reading a statute, and that particular statute that discusses the penalties of $500 a day also discusses that an employer will not be liable for this penalty if they pay all the fines and all of the wages and all of the money that they're required to pay under California Labor Code Section 1402. Then the damages, then that penalty will be reduced. So if you keep on reading up the statute, it says that your employer's liability can be reduced if they follow Labor Code Section 1402. And what California Labor Code Section 1402 says is that the employer should pay all the back pay, but if your employer is paying all of your wages up to the date of termination, that you don't have any back pay. But then, if your employer gives you all the money that you should have been entitled to had they had given you proper WARN notice, then there is going to be no penalty. Now, let's look at this. Let's look at what you should have been entitled to had you been given proper WARN notice. You would have been given 60 days notice of your termination, of your layoff, meaning you would have gotten 60 days of wages. Now, if this severance agreement that Twitter is actually providing people is 60 days notice, then that is the damages. That is the amount of money that the employer should have received if they were given proper WARN notice. So now let's go back to this lawsuit, right? If we're looking at the California Labor Code, and we could see that the damages would be reduced by the amount of money that your employer pays you voluntarily in order to reduce the damages and liability of not giving you that WARN notice. If they give you the exact amount of money that you should have received during that WARN notice, what are your damages? Now, if we're looking at the lawsuit, I've noticed that the law firm that is suing Twitter in this case is, I believe, a similar law firm that sued Tesla in Austin. So I'm not going to opine too much in the lawsuit because I haven't read all the filings and I do not plan to do so today. But what I will say is, if what Elon Musk is saying is true and he's giving people a 60-day severance and people were required to receive 60 days notice and 60 days of wages, do you think he's going to be liable for very much else? Or do you think he's just going to be liable for potential damages that are being incurred from these employees retaining and paying for attorney? I don't know. But like I said, we're going to find that out. I guarantee these lawsuits will be in the news for a while. One thing I would look out for if I were y'all is to see if this case actually gets dismissed. Because if we start looking at the penalties, if we start looking at the damages, and then we find that Twitter is actually complying with all the laws, and we find that Twitter is actually paying their former employees the money that they should have been entitled to had they been given WARN notice, what are the damages? What's this lawsuit really for? Now, before everyone gets really excited and say, hey, I'm going to join a class action lawsuit against Twitter, I highly recommend that you speak with an attorney to talk about your individual situation. Because in a time right now where there are such mass layoffs, there are other requirements that your employers required to follow. For example, even if there's a mass layoff, if you're over the age of 40 and your employer terminates 2 or more people who are over the age of 40 in one termination setting, which in this situation is a mass layoff, then your employer is required to give the people over 40 a list of all the people who are terminated, not their actual names, but their duties, their salary, and how many years of service they've been there and how old they are, in addition to the severance paperwork that Twitter is providing its current employees. Now, what this is for is this is allowing the older employees to analyze, determine, and really get additional facts about if they possibly are being discriminated against based on the ADEA, or the Age Discrimination in Employment Act. Now, I'm not looking at this as only a Warren Act issue. I'm looking about any time your employer terminates 3 or more people over the age of 40 within a very short period of time or in one termination setting, then your employer is required to provide you with that information if you're over 40. Now, unfortunately for the people who are under 40 like myself, number one, I can't wait till I'm 40 because then I get these additional rights and protections that will protect my employment. But number two, if you're under the age of 40 and you're subject to this mass layoff, your employer is just required to give you the Warren Act requirements, not any of the ADEA or OWBPA requirements. So I know all those requirements are information and facts for another video, but I just want to pose the question. If Twitter was supposed to give 60 days notice to all their employees, which means they're also entitled to 60 days wages, but Twitter gives none of that and they fires people immediately, but then they still give 60 days of pay, 60 days of severance. Do you think that's fair? Do you think that's legal? Would you be happy with that? If you like the information I shared in this video, I did some background research and I am a California employment lawyer, so I did have information on the Warren Act readily available. But it would really be helpful if you liked, comment, subscribe to this video, and also watch some of my other ones, because then that would help encourage me make more videos like this, because, you know, I always want to make my research correct, and I always try to give y'all a little middle of the line perspective. So if you enjoyed it, I hope to see you next time. Thanks, and tune in.